the things and penalties of perjury and testimony you give today will be the truth?
Yes, Your Honor.
Do you recall the early morning hours of April 21st, 2024?
Yes.
To your best recollection, do you recall that we were pulled over by Officer Makita?
Yes.
And what do you remember about that traffic stop?
After he pulled us over?
Like what led up to the traffic stop?
Oh, he was sitting in the roadway when we were getting ready to turn. He was going left and we were going left. And then we turned and he turned right instead of going left and followed us.
Like you mean his, he had a turn signal indicating that he wanted to go the opposite direction?
Yes.
And when did you realize that it was a police officer that was following us?
As soon as he turned behind us.
And approximately how far down the road do you think he had pulled us over from when he began following us initially?
2 miles.
What do you recall happened after when he approached the window?
He asked me to get out of the car right away. I believe. Yeah.
Did he state anything previously before ordering me out of the vehicle?
Oh, what do you mean?
Like, he ordered me out of the vehicle, but did he say anything previous before ordering me out of the vehicle? Like, did he say something to me?
Like why he pulled you over?
Yeah.
No. I don't recall it.
Did he give a reason why he stopped?
Yeah, he gave a reason.
What was the reason?
He swerved off the side of the roadway, I think. Or touched the grass, maybe, he said.
Now, what was your initial thought when he gave that reason for why he pulled me over?
I thought it was a lie.
And what do you recall from the rest of that traffic stop?
I went to jail.
Right, well, what led up to that you recall?
Me going to jail?
What led up to after I exited the vehicle?
Oh, he pat you down. I was recording it. He pat you down. He got his dog out. And he searched the vehicle. After he had me get out of the car. Also.
And to your knowledge, the protective order that was reported was essentially dismissed, correct?
Yes.
So to your recollection, you were initially surprised to hear that it was still active.
Yeah, I was very surprised.
And have you discovered anything further regarding that protective order?
Your Honor, I'm going to object as to relevance.
All right, so ma'am, the objection's relevant, so how does this relate to the motion to suppress? That's my question.
Well, it relates to it because it was the whole reason why I think the series of events that happened happened because had the protective order been taken care of like it was supposed to have been, none of this would have happened, in my opinion.
I don't. So, all right, so it's motion to suppress. So we're talking about whether or not this fits into exceptions to the warrant for. So I think everything I've heard is this, is that there was a protective order that was showing in the dispatch system was still active, and then you all said it was inactive. And then, so that's where the evidence I'm hearing is. And so he's getting ready to say what? What's he getting ready to say? Do you know? I mean, I'm assuming you know, you're asking him a question, right?
Yeah.
What's he getting ready to say?
Probably because there was a failure in the prosecutor's office to not update the system as to why it was not.
So, is he just going to tell me that it was still active in the system?
It showed still active in the system.
Okay, well, objection overruled. Go ahead and ask him the question.
Do you reflect on what I screaming?
No.
Was I calm and respectful of the officer for the most part?
Yes.
Do you recall anyone else from the public or like outside of the officers and us to
No.
being present?
No.
No further questions.
Cross?
Just a few, Your Honor. Did you tell your wife to get out of the vehicle during the traffic stop?
Yes.
Okay. And you said that Deputy McKee gave a reason that your wife swerved off the side of the roadway. Would you agree that that's a traffic violation?
No.
You don't agree that to swerve off the side of the road is a traffic violation?
No.
Okay. Now, you testified that you observed the pat down and the canine search, is that correct?
Yes.
Okay. I don't have any other questions, Your Honor.
Redirect? Redirect?
You say that you don't think that swerving off the edge of the road is a traffic violation. It's because it didn't happen, correct?
Yeah, that's correct.
No further questions.
Recross?
Nothing, Your Honor.
Any other witnesses, ma'am? No? So you're free to go back outside, sir.
Pardon?
You're resting?
Yes.
Okay. No, I'll just go ahead and hear the argument now, watch it later, because I assume it's probably 30 minutes long, right?
Probably about that, or maybe a little longer.
Go ahead and argue.
Thank you, Your Honor. From the state's perspective, the officer testified, then Deputy McKee testified that he was engaging in his normal duties as a deputy, that he observed some traffic violations to include the flashing of emergency lights, or excuse me, the flashing flashing of bright lights on the roadway, and that he turned and he followed the vehicle that engaged in that conduct, and that he observed some additional traffic violations, and that he engaged in a typical traffic stop to address the citations that he observed along the roadway. In terms of what happened next, what Deputy McKee testified to is pretty standard. He approached the vehicle, the individual inside of the vehicle was already dead, and so he acted accordingly in terms of removing her from the vehicle based upon his training experience, and removed her from the vehicle to protect his safety as well as the safety of the other officer. From what it sounds like, Mr. Risner was cooperative, and Mrs. Risner was not. In terms of the search, I don't think that Deputy McKee acted outside of any type of restraints that he is allowed to in terms of utilizing his canine when engaging in a traffic stop. He testified that he had, based upon the behavior of Ms. Risner, reason to pull his canine and run the canine around the vehicle. He also indicated that he has working knowledge of what it means to prolong the traffic stop, and there was nothing in evidence to indicate that he did anything to prolong the traffic stop. Now, while it's my understanding, based upon what Ms. Risner has filed with the court in terms of her motion to dismiss, as well as some of the evidence here today that she seeks to suppress the search, but there was nothing found in the search. The dog alerted, he ran the dog around, and the subsequent search produced nothing. In terms of the conduct of the defendant, that was something that was that started at the beginning of the traffic stop and was something that she engaged in through the end of the traffic stop. Deputy McKee testified that he had a valid basis to pull her over in terms of observing those traffic violations. He also testified that the reason he waited so long to engage in that stop was because he wanted to do it in a well-lit area, also based upon his training and experience in making sure he was in a safe location to engage in that traffic stop. I think based upon the totality of the circumstances that the state has met its burden in terms of the search, in terms of the conduct of the officer, in terms of the fact that there was not a prolonging of the traffic stop here for the canine search, and that there was a reason to run the dog. I would ask that the defendant's motion to dismiss be denied.
What is the statutory side for the failure to deem infraction?
Oh my gosh.
Same thing for failure to maintain lane.
Can you give me? Yes.
Is everyone going to agree and consider whatever testimony I've already heard for the motion to dismiss to?
Yeah.
That's fine, Your Honor.
Do you agree with that, ma'am?
Yeah.
Okay, all right, so we'll get the motion to dismiss after we do all this, but, all right, while the state's looking that up, go ahead and make your argument, ma'am.
Well, when you observe the evidence, it's pretty clear that his statements and his probable cause affidavit and his statements from his testimony, they're not going to corroborate with what you see on the objective evidence. He did not have a lawful basis to pull me over to begin with, because striking the edge of the roadway is not even an infraction in the state of Indiana. And he didn't have probable cause to even get his canine out to conduct a free air sniff. Just because I was argumentative is really irrelevant, because they, as police officers, they deal with members of the public every day. And in the Supreme Court ruling on City of Houston versus Hill, a person who's argumentative with police officers is not considered disorderly conduct.
Okay, so let's focus on the motion to suppress. We'll talk about motion to dismiss here in a minute. So we're talking about, let me just kind of reframe this for you so you can, so there's a couple different things going on. So one, there's the stop, right?
Right.
So it says there were 2 infractions, and a question in the state about exactly what the Indiana code said constitutes those infractions. You were operating on intoxicated, and then there's the question of what suppressing from a search that yields nothing. So kind of what we have started to stop, okay?
Alright. Well, the video evidence will show that my vehicle never leaves the roadway. From the part that is recorded on his dash cam, there's no observable traffic violation on the video evidence. That's all I got. I mean, the evidence the video evidence will show that there was no observable traffic violation that had occurred, and his statements that he makes in the body cam footage, where he had said that I had struck the edge of the roadway back there, which would, I guess, say that he observed it within the time frame that my vehicle was shown in the video, and there was no observable traffic violation. That's it.
Okay, do you know what the failure to dim code section is? Let me ask her first. Do you have the failure to dim code section or the maintain lane code section?
No, I
No?
don't.
Okay, all right, stay.
Failure to dim.
All right.
Failure to dim is 921.
921, what?
921-851. I'm looking at 2 different things, I apologize. It says a person may not operate a vehicle and fail to dim bright or blinding lights when being in their vehicle or pedestrian.
Okay, and then the maintain lane.
sorry, this isn't the right one. Hold on a second. This is, I'm sorry, it's 921.82. Vehicle should be driven on the right side of the roadway when overtaking passing the vehicle. Proceeding in the same direction in these rules. When the right half of the roadway is closed, upon the roadway divided into 3 marked lanes. Upon all roadways, the vehicle proceeding at less than normal speed. Upon all roadways, a motor vehicle, a motor driven, oh, that's a cycle, I'm sorry. Just have this up here. Oh, excuse me. Upon all roadways, a vehicle proceeding at less than normal speed of traffic at that time should be placed in conditions. Let's see there. Hold on. I'm gonna have to look because I can't find the IC code for that.
Okay. All right, so I'll take that issue under advisement, and we'll watch the videos, and so I guess we're going to deal with the motion to dismiss now, so I've already taken the consideration evidence I've already heard, so it's your motion, ma'am, so we're going to make whatever argument you want to make.
Well, when you observe the video evidence, you'll observe on his dash cam footage that there was no erratic driving, there was no lane leaving or evidence of impairment, or no traffic violation observed. Under the 4th Amendment to the United States Constitution and Article 1, Section 11 of the Indiana Constitution, an officer must have reasonable suspicion or probable cause to justify a stop. In State versus Rager, the 2008 Indiana Court of Appeals ruling, the court held that the state bears the burden of showing that the measures it used to seize information or evidence were constitutional. And here I don't believe the state has met their burden. I believe this stop was based on a lawful observation, or it was not based on a lawful observation, it was based on a pretext. The decision to follow and detain was without justification and a clear abuse of discretion and violation of my rights. I mainly questioned the legitimacy of the stop because I know that I didn't strike the edge of the roadway, and his report also does not cite any observable indicators. No smell, no nervous behavior, no visible contraband, nothing to justify escalating the stop or escalating to a search. In Rodriguez versus United States, the Supreme Court held that prolonging a traffic stop beyond its original purpose without reasonable suspicion is also a violation of the Fourth Amendment.
So let me cut to the chase here, man, before you keep going on. Let's say I find that search was totally bogus. How does that affect anything for you?
Well, it could get the rest, I mean, if that could get suppressed, then if you found that that was bogus, then the state wouldn't have any further evidence of my statements or,
Were your statements in the car?
pardon?
So were your statements in the car?
What do you mean?
So I'm saying, what was the fruit of the search? That's what I'm asking.
Nothing, really.
Okay.
Well, if we're,
That's what I'm trying to understand, what you're asking me.
yeah. Mainly my statements, really, if anything was to get suppressed. But I don't know if we're getting away from like the traffic stop itself, and considering on the charges or just the charge, then I think in order to sustain that charge, the state has to prove all the elements of the charge, and they have to be able to prove that the conduct occurred in a public place, that I acted recklessly, knowingly or intentionally, that I made unreasonable noise, that I was asked to stop, and that I continued after being asked. And where the incident or the traffic stop had taken place at was in a rural fire station parking lot late at night, so there was no members of the public present. There was no passersby or anyone that even really seen what happened. The state is also in the Supreme Court in Whittington versus State. They over overturned a disorderly conduct conviction where the conduct occurred even inside of a private home and did not disturb the public. I didn't act with any recklessness or intent to disrupt. I, for the most part, was calm and cooperative throughout the whole encounter. The officer's probable cause affidavit is mainly conclusory statements. He claimed that I was yelling and screaming, but his statements are not supported by the video evidence. And even in the Indiana Supreme Court Price versus State ruling, the court ruled that private confrontations or arguments with police officers without more do not constitute disorderly conduct.
Can I ask you something?
Yeah.
Okay. So all these cases you're citing to me, these are all appeals, right?
There was Price versus State was a Supreme Court ruling.
Sure, but they're all people appealing their conviction, right?
Right.
Okay, so how did they get to that point?
Well, they had to.
Trial, right?
Yeah.
And lost,
Yeah.
and then appeal,
Right.
right? So we have the state here saying one thing, right?
Right.
And you're saying another thing, right?
Right.
So you asked for a jury trial, right?
Yeah.
So in that circumstance, who's the person tasked with weighing the credibility of the witnesses and determining what the truth is?
Well, it's the state's burden to prove.
Right, it's the jury could weigh the evidence,
Right.
right?
Yeah.
Okay. So do you have any authority that lets me, at this stage of the proceeding, kind of invade into their job? Right, because I think all the cases that you cite always end one of two different ways. It's a person was trial and they were convicted, which obviously if you were acquitted, you wouldn't appeal because you would have won.
Right.
Or the state's finished the presentation of their evidence and there's been some motion made that they didn't meet their burden based on what was presented on a legal standard. Right, so what I'm asking is, do you have any cases, because there's tons of those cases, right? It's a highly litigated issue.
Yeah.
And you correctly cited all kinds of them. There are all kinds of defenses you'd have at trial. But is there anything you have?
Right.
You're all over the place identifying all kinds of nice things to raise at trial, but you don't have anything.
Well,
I haven't seen you show me a case that says, at this stage of the proceeding, I can do anything about it.
well, in the elements that have to sustain a charge of disorderly conduct, I don't believe the state has all of the elements necessary that a reasonable jury would convict me of that.
And you'll win.
Well-
That's how it works. That's what I'm trying to understand, man. It is, I'm just asking you, if you have any case, right, with it, in this context, I can grant you the relief you're asking for, right? Because you're essentially asking me to do this. You're asking me to weigh the credibility of witnesses in a pre-trial hearing where the rules of evidence don't apply. That's what you're asking me to do, and then enter a final judgment based off of that.
Right. So I'm sorry, I misunderstood what you were asking.
Okay. Let me try this again. There's tons of cases, right, that say essentially this: you can't short circuit the process. I'll give you an example. say the state files something and there's no probable cause. What they put in the probable cause affidavit isn't even close to being a defense. They can still proceed forward to trial, and they could even win at trial, but the person couldn't be held in jail because there's no probable cause. And so there's all these cases, and this motion is dismissed, and we talked about this last time, on the last motion we filed, and that's why I'm just bringing it up again. Did you find anything since the last time that says in this particular situation, that process is short-circuited because of this?
Well, in the charging instrument, they don't state the facts with sufficient certainty. They're not very specific at all in the charging instrument. They just say, it says that I made unreasonable noise and continue to do so after being asked to stop. And that it's not very specific or anything. It's conclusory, and they're supposed to state with sufficient certainty on exactly what I'm being charged with.
Like, will you agree this orally too? Is that what you're saying?
Yeah, under the amended criminal information, it just says that on or about April 21st, 2024, in the county of Stark, state of Indiana, Rebecca Risner did recklessly, knowingly, or intentionally make unreasonable noise and continue to do so after being asked to stop. Doesn't give any context, which is not very specific, and under 353414 A4 and 5, the indictment or information does not state the offense with sufficient certainty, and the facts stated do not constitute an offense.
Do you know what that means in the criminal context, though?
What?
If you look at the appellate case as well.
What do you mean?
No, I'm just asking, have you looked at the appellate cases interpreting what that means for criminal cases?
No.
No. does, just let me
Yeah.
know and I'll
Just read it, what you brought down. I know how to say it. He does all right there.
Everything I'd say.
Nothing else? Okay.
Your Honor, I would ask that the motion to dismiss be denied. Sufficient evidence has been presented in terms of the fact that there was a traffic stop. There were multiple violations in terms of the demeanor, the failure to dim the lights, as well as behaviors observed by the officer that could lead him to believe that there were behaviors present when the person may be intoxicated driving the vehicle to include leaving the roadway. I think that in terms of the search, the court said it very well, that what would happen, what's the remedy if the search is even suppressed? It doesn't change the conduct in terms of the disorderly conduct. And I think that there has been sufficient evidence for this case to remain and still pend and then go to trial based upon what the officer testified to today. So I would just ask the court to deny the motion to dismiss.
Okay, so Amanda, you want to respond to anything I said?
Oh, the officer doesn't state any, observations that he thought that I was under the influence or anything like that in his probable cause affidavit. He doesn't.
Your Honor, if I can, he testified to that. That's the thing here, not
All right, hang
specifically.
on, she's talking, don't, if you want to object, but don't just talk to the top of her. Are you going to object?
I am objecting because he testified to all of that.
Okay, so let me clear this up for you, ma'am. You didn't offer the probable cause affidavit in the evidence. You didn't testify. I heard from your husband and I heard from the officer on the motion to suppress, and I took that into consideration here in the motion to dismiss also. So, and we also have the video, which I'm going to review the video when we're done. So, you know, you're referencing a lot of things that aren't even.
Well, his probable cause affidavit is in one of my exhibits that I filed with my motion.
You didn't offer it in the evidence.
Okay.
And he also testified, and you didn't impeach him with any of the statements in there. I'm just being real straightforward with you here, okay?
Yeah.
Just letting you know, okay? So is there anything you want to respond to based on what I've heard?
No.
No, okay. All right, so I have a couple questions, if that's the end of the argument. So one,
Yeah.
yeah, you did a very good job. I would say most people, I've only ever seen one other person do this good work and hit all the issues as well as you hit all the issues, and that guy had been in prison for most of his life.
Oh, really?
And had a lot of time to read. So you did a very good job. You should probably consider going to law school. So I'm not seeing anyone who represents themselves do this good job. There's a couple of problems though with your motion to dismiss. I'm going to just go ahead and, I'm going to take both of these under advisement, but, unless you give me something before I leave here that's real clear answer, this is kind of the same problem I told you about when we were here last time. In the criminal context, a sufficient pleading is really just something that states the elements of the offense, the date of the offense, and your name in the criminal context. What's in the probable cause affidavit is just for the ability of the court to generate probable cause to hold someone. It doesn't really mean a whole lot outside of that, because it is entirely possible, and you look at the appellate cases yourself, where there's no probable cause and the state can still take someone to trial on an information. When I look at the information, the amended information, it has your name, the date, the mental state, and then the elements of the offense. That's a sufficient pleading, unless, right, maybe you're claiming alibi or some other highly specific offense where you would need a more definite statement as to time, place. There's a statute that controls the state filing certain things to do that. So unless you can give me something other than what I understand the law to be, that's kind of how I see that issue. The other issue is kind of what I've been trying to explain to you, and I explained to you the last one. So one, I don't even know that I really have to even rule on your motion because I've already denied it once, but you don't understand that, so I set this hearing because you have to do the motion to suppress anyway. But it's the same issue on the motion to dismiss that you had last time. Right? And I don't believe there's any legal authority I have to do that at this point. So it's a misdemeanor. Normally you would have gone to a bench trial. If you had done a bench trial right, we could have done the trial, the motion to suppress and everything today and just been done. But you requested a jury trial. And so what that means is there's going to be a presentation of evidence, and the state has to meet the burden. If you want to present evidence, you can present evidence, but you're not required to. And then it's the jury that has to weigh who you believe and make the final determination of truth. I don't know of anything that would let me do that at this stage. Now, some of these issues you may be able to raise after the state's presented their case in chief in the jury trial, and maybe the jury never gets it because of some legal impediment. But there's a couple things I'm just going to point out here. Where the noise is taking place, that's a factual question, right? That's the jury.
Yeah.
Whether or not the content of the statement is protected by some constitutional amendment is somewhat of a legal and factual question, but I didn't hear any facts today about what the content of the statement was, right? Everything I heard today was one of two things. You were yelling, screaming, and cussing, or you were polite. Nothing about the content was said by anyone, and I don't understand why. Maybe I'll hear it in the video. I'm going to have to review the video to find out, but that's one issue in dealing with, these First Amendment right protection type cases. Has anyone found this maintain lane statute?
Yeah, I think that the IC code, and I apologize, I closed out of it to open up something for my next hearing. It's 922.811.5, I think would be what would apply here.
So I'll have to look at what it says and you can.
I don't, and I apologize, I closed out to pull up some things.
Okay.
It's my C codes for my next hearing.
All right, and so I kind of already posed to you what I thought the three questions were for the motion to suppress. Do you want to take some time to see if you can look up these code sections or anything, ma'am? I can take a break and come back in here, and then I'll give you two an opportunity to talk about the video. Because I don't want you to feel like you're hamstrung because she has a computer and you don't have it.
Well, as far as your question regarding the failure to maintain lanes or whatever, are you asking, like, if that is like an offense, basically, like traffic violation? And
Well, I mean, I'm always asking. So there has to be the reasonable suspicion of a criminal offense or
right, but
the question is what does the statute that they're saying applies say?
right, but if that was the case, why wasn't I written a ticket for that? And he didn't even mention that at all.
So I'm going to watch the video, man, and I'm going to take all the things into consideration. And so my question is, because you got me off track there.
Sorry.
We need to take a break and give you time, one,
Yeah.
to talk about the video thing, and then two, see if you can look at these statutes and see if you want to say anything else before we conclude.
Yeah.
You want to do it? Okay.
Sure.
So we'll take a little break and pause the record.
Your Honor, I have another hearing at 11 that I have to go and do as well.
Okay.
With the sentencing, so I can just move on with that. I can meet with her about the video in the event right away.
All right, and then, ma'am, you'll have time to do whatever you want to do, look up things, and then I'll come back in here when everyone's ready, and I'll let you make
whatever other argument you want to make after looking some stuff up. Okay?
All right.
Last hearing.
Very close. I got it.
Calm down. Calm down.
What he's trying to find from you is what you know and what you have written here. What he doesn't want you to do is present evidence for a trial because that's what you're doing. Does that make sense? Huh?
The evidence has to be presented in order for him to make that
Right.
consideration.
And they're gonna look at the tape, okay? And if he sees that this was not normal, okay, you may dismiss just what you did. Don't let him get to you.
And he was asking you about the other pieces, he wanted
She's
a
over there.
thing before they went to trial, if there was anything there, that's what he was wanting.
And how the heck does she not know what's on this tape?
Well, that's what I wanted to say
She don't know
initially.
because it was given.
She didn't look at her. She's never said it.
I wanted to say what, yeah, while she was standing there looking, like, I just wanted to be like, well, shouldn't the state already know this?
They should.
With the dimming thing, you gotta come back on. He had his brights on
I
and
know,
you
but that
dimmed
would be
him.
me having to testify, and I had already.
But they can't keep saying that you failed to dim.
But you
Well,
know, a
even
lot of
then, they
this,
didn't write me a ticket for it or nothing.
a lot of this is
They're
his
just
word
gonna-
against yours.
Yeah.
They're just gonna say discretion on the no ticket. He doesn't have to write a ticket, so.
No, you don't have to. But it's boiling down to his word against yours, then how does his rate higher than yours?
No, there's, the video will take care of that,
Yeah.
his against hers, but as far as, I'm just surprised that they can't
Look
dismiss
up that code that he said.
charges based on the fact that they're bogus charges. He can't dismiss them, they have to go to trial. That's the legal system,
Well,
though.
they can't say they're.
The thing that he's trying to do is he's trying to help you out.
Voice their opinion.
Did you notice
I hear it all
that?
the
No,
time.
no.
He's trying to help you
I
out.
mean, they all do it. And they
He
file charges
can't, he
against all of
can't
them.
physically
It's crap.
Yeah.
do
We don't have
it.
no
He
right.
can't come and say, this is what you need to do.
Right, well, I know that.
And
I know he can't.
he appreciates you. Believe it or not, he does.
Oh,
Well,
yeah, if he didn't, he wouldn't have said what he did about her write-up.
well, here it says that the only Indiana code for failure to maintain lane is 921.8.11.5, but that states that when a roadway is divided into clearly marked lanes,
Exactly.
the vehicle must be driven as near
Ask
it
him,
is.
was there a, what do they call them now, fog lines?
Yeah,
Was there a white line on the right side of the road? No, there's none of them out here have that.
Key points about this law, drivers must stay within their lane lines as much as possible. This
Plus,
is
at
exactly
night, how
what
the
she
hell-
was reading, so she must have been doing just a damn Google search.
She's seen it and stopped.
I seen it on her phone.
So she didn't want
At night,
it to blow the case apart.
1 o'clock in the morning in
It
April.
would have blown her case apart if she'd kept reading it.
Yeah.
So she stopped and said, oh, that's not the right one. No, that's a prosecutor trick.
He knows.
That's
He
why he,
knows. That's why he's,
That's why he told you to look it up.
Write that down.
Yeah. Sorry, I could find it.
he's giving you every opportunity before you walk
She's
out.
trying to deflect, but oh, I'm looking up other cases. Well, you're on this case right here, right now. You shouldn't be looking up your next hearing.
Yeah.
That's how she got out of that, finding that. 'Cause she already had it. She was reading it and said, oh, that's not the right one. Stop reading it. She knew it was.
But that's why he's wanting me to look up those two codes. There's something in there.
Yep,
So it was the failure to maintain lanes, and then the other code he wanted me to look up was,
Brakes.
yeah, or whatever. I've never heard of
We
that.
righted him
Yeah,
to them.
because he was,
He was brightening the hell out of it. You should have asked me that. I didn't know what he was wanting me to, if he wanted, I didn't know what the hell he was asking me.
I don't know that's gonna change it.
I could see that.
Well, that's the reason why he began to follow her, because he failed to dim.
Yeah.
Well, we didn't, we brided him.
The
Especially when
suppress
she's
thing
getting
was,
close to doing,
that stop should have never happened, and if the stop never happened, the behavior would have never been recorded.
Exactly. Well, I'm telling you, should have never happened if it.
well,
So the evidence for the disorderly conduct would have never, and you would have never went to jail
Yeah.
on a
Yeah.
bullshit record-keeping issue.
yeah.
I'm sorry, my language.
no, you're fine. I've heard worse.
You don't know what I want to call her.
Well, I haven't
The
It's all the way they
hilarious
word.
eye
It's all the way
rolls.
they
Yeah.
throw words in there, you know, like her.
yeah.
Yeah, Beck, just be confident. You're doing a good job. You're stressed, for one. It's okay.
Yeah.
Go,
You've done your homework, and he's trying to help you.
Yeah.
a
Yeah.
little late now, I think, though. Just argue. Go ahead and state your case, and even though if it sounds outside of, just let it go, so you're not keeping that inside. All we can do is object. That's the worst they can do.
Yep.
Yeah, he's like a street dog.
Nice.
You're getting rattle-brained.
Yeah, she just wants her butt out of the sling. That's
All she wants.
all she
Yeah.
wants.
Oh, I know.
Talk like you're talking to us, telling us about the story.
Thank
Say that.
you. Thank
That's what you need
you.
to say.
Yeah.
Yeah, that robe doesn't mean, he's probably got fruity underwear on.
He's wanting you to come out with everything. That's why he's giving you that chance.
What is a magistrate?
He's like, the judge appoints him, basically.
So he's not a judge?
Well, technically he is.
Oh,
but
okay.
I mean, he rules on,
Okay.
he oversees cases just like the regular judge does.
Oh, but he's not elected.
No, he's not.
Okay.
Here's the thing I get with that. You know what RN and an LPN,
Yeah.
kind of like that.
Okay, all right.
Yeah, I know, right? Let's pretend.
I can, that's the only thing I can think of.
But see, the RN has the higher authority, but I can operate under an RN. Yeah, same thing.
His patient, like I would see his that
But you need to clarify the filter to dim thing. That's bullshit. That ain't how it went down.
Where's all that lights?
Again, that's,
You got all these damn pickups running around with fog lights on, headlights on, blinding everybody. What the hell is the difference? I get that shit all the time. I can't hardly see.
Well, yeah,
That's all.
and his headlights,
whatever.
But
they
that's-
were ridiculously bright.
Yeah, he has to go from.
that's evidence at trial, though. You gotta be at trial for all that stuff to get
I know, it's
spewed
all,
out.
it's out there. I mean, you ain't the only one that's ever cussed a cop.
Yeah.
Somebody.
That's why I was trying to make that argument as far as like the Supreme Court ruling on the city of Houston versus Hill or.
That stuff has to be put
Price
into the
versus
trial though. That has to be done in trial.
It won't take them long.
Yeah, but see what he was
We'll have,
Is there any evidence before the trial of them releasing this, this, canceling out your charges? That's what he was looking for.
Yeah,
He said all they have to do is file an affidavit and you can go to trial, whether it's bullshit or not.
Yeah,
Again, what they could, that's
Which is stupid.
the lady over there.
Which is stupid.
I
Why wouldn't
agree.
you review the evidence and everything as a whole prior to even filing charges.
Like a grand jury.
Yeah, that's.
That just blows my mind if he hasn't even seen that.
I don't trust any
Does
of
that not blow your mind?
I thought it was up to the judge to find probable
Hadn't
cause.
even looked. She doesn't care.
It's supposed to be.
Well, say that, bring that up.
You
She
think?
Yeah, she just don't wanna,
I'll bet they have.
yeah,
Is there a code on that?
yeah.
But she said
So,
Well, for him to make a decision on,
I think there is.
She's read it.
you need to look that up too.
I'll bet she
Look
has.
at that.
No.
You want to,
Can't even do her job, how come in the rest of the understand? She don't even do her damn job. She don't.
She deflected on that.
She probably did.
She deflected
Yeah, she
on
never
that
looked
too. Because that,
You're suing them, aren't you?
trying to.
Okay.
That's negligence on her part. That's her problem.
Just present to him the type of information that he wants
Yes.
without
Yeah.
presenting evidence for a trial, because
Yeah.
that's what he's
Yeah,
looking for.
yeah.
Basically, what do you want out of this hearing?
Right.
In your own words.
Why should he drop it?
You know, I think that these charges are bogus, and it shouldn't ever get to this point.
well, no.
And basically, I feel the cop, got his feelings hurt.
Yeah,
Probable cause, there isn't any.
Yeah.
There is none.
you
Well,
know,
see, now it's like he's ignoring the probable cause affidavit and is only taking what he testified to
yeah, because
here.
you didn't enter
You
it
didn't
into
get
the
the,
See, I thought,
deposition.
I thought it's already in evidence.
that's what I thought.
It's
By
fine.
filing it as an exhibit with my motion, I thought that meant that it was already in evidence.
Oh, well. You're learning a lot.
A lot.
That's okay. Learning is good.
Yeah.
Yeah.
You stop learning and life ain't fun no more.
Just be confident. Just be confident. You're doing all right.
Does that like you're talking to us when you're presenting it?
Yeah.
Yeah.
Just don't use the F-bombs.
Yeah.
You learn stuff every day, just like
There
the
was
other day.
another question that he had asked for me to look up too on any cases that
Basically, we're
were
dismissed
dismissed
before trial.
trial, but see, it wouldn't.
It would never, there wouldn't be a court
cases.
record.
Yeah, there wouldn't be any cases because there would have been nobody to appeal it to the higher court for them to rule on that.
That's,
Unless the state objected to it and they went that far. But I don't.
Or maybe this case will go on the annals. I'm
you're
just
making,
saying.
you're making history.
Yeah.
Tell him you can't show any cases because there isn't none.
Just find the two things he was asking you.
Yeah.
Well, I need to look up the actual. How many 51 addresses these